trained to fight, and forced to defend. This is a case about one dog that was trained to fight, and another forced to defend herself and her family. Every day, innocent dogs are forced into the world of dogfighting. It is a world of violence and aggression where these poor animals have two choices: kill or be killed. When these dogs are saved from that world, there are some that can adapt to a new way of life, but others simply cannot change. People debate whether this is due to genetics or environment, breeding or training, nature or nurture. But in this case, that doesn't matter. All that matters is that this pit bull was simply too scarred, too aggressive, and most of all, too unpredictable to adapt to life as a domestic pet. Because of that?
Let me ask you a question. Wouldn't it be accurate from the evidence that we could conclude that, in fact, Goldie was trained to kill and trained to hunt, but we really don't have any evidence that Pitt was trained to kill or hunt? All we know is that he came from a house where animal fighting took place.
We do know from the evidence that Pitt was trained to fight because it was saved from a dog fighting house, whereas there's no evidence in the record to support that Goldie was ever trained to fight. Officer Danger herself testified that there was nothing at Mr. Elvick's house to suggest that this was a typical dog fighting house, perhaps bait animals or bait cages or anything along the lines that would suggest that Goldie had been trained to fight other dogs.
But she was trained to kill small mammals or to hunt smaller mammals.
Kill would not be the right word to use. Goldie is a golden retriever who is trained to retrieve animals such as squirrels and pheasants after they had been shot by Mr. Elvick, who is admittedly a hunter. But a golden retriever is trained to retrieve, not kill. But this pit bull was trained to fight. And when this pit bull attacked, Goldie was forced to defend. Because of that, Mr. Elvick sits before you today, wrongly accused of engaging in and trying to include his son in a dogfight. The state has charged Mr. Elvick with endangering the welfare of a minor, engaging in animal fighting, and conspiracy to engage in animal fighting. It is the state's burden to prove Mr. Elvick guilty of these charges beyond a reasonable doubt. Reasonable doubt is doubt based on common sense and reason. Reasonable doubt means an honest uncertainty as to the guilt of the defendant. Reasonable doubt exists when, after careful and impartial consideration of all the evidence in the case, you are not convinced to a moral certainty that the defendant is guilty. The defendant is never required to prove his innocence or to provide any evidence at all. This means that if the state has failed to convince you to a moral certainty of any element of any charge, you must find Mr. Elvick not guilty of that charge. The crime of endangering the welfare of a minor required the state to prove that Mr. Elvick knowingly or unjustifiably placed a minor in danger of imminent harm, or knowingly and unjustifiably encouraged a minor to engage in unlawful behavior. Mr. Elvick told you that on September 14th, he got up before sunrise. He got his dog Goldie and woke up his son Mikey to go and warm up in the public woods before a day of father-son bonding and hunting.
Counsel, let me interrupt you. The testimony was that, and I think your previous arguments have been that Mr. Elvich Jr. is not to be trusted because he's rebellious, ran away, has a felony conviction. So we have Ms. Pawson, Mr. Hirsch, Ms. Danger, Mr. Elvich, and then we have your client. So why should we disbelieve those first four witnesses and just believe your client, who obviously has a great deal to gain and lose from this prosecution?
Well, it's important to remember that Ms. Pawson did not see this fight begin. So she was inside her home. So you have to consider her ability and opportunity she had to see, hear, or know the things that she testified about. Ms. Pawson testified that when Goldie was attacked, she was inside her home. She only saw the aftermath of this dogfight. And Mr. Elvick used a dog whistle to command Goldie to retreat in an attempt to separate the two dogs. Despite seeing only the aftermath of this dogfight, Ms. Pawson blamed Mr. Elvick for a fight between two dogs. She blamed him because he had asked her to control her pit bull. You heard Mr. Elvick left a note on Ms. Pawson's door, asking her to control her dog or he would have her cited. But Mr. Elvick never threatened any violence against Ms. Pawson's pit bull. He was just worried because in his 35 years of police experience, he had seen...
Can we go back to this endangering the welfare of a minor? Because I'm a little confused. Wouldn't it be harmful and put his son in harm's way for him to even bring his son out to the area where the dogs are fighting? Specifically because your client knows how much damage a pit bull can do to a human?
But Mr. Elvick did not knowingly or unjustifiably put his son in danger of imminent harm. Mr. Elvick went to warm up before a day of hunting and father-son bonding, unbeknownst to him that while in these woods, he and his son would be approached by the neighbor's pit bull. A pit bull that was not in its yard, which was 50 yards long, was not tied to a leash, but was approaching Mr. Elvick and his son. At that moment, when the pit bull attacked, Mr. Elvick and his son were placed in danger of imminent harm. But it was not imminent harm that he knowingly or unjustifiably placed them in.
Did he not ask him to follow with him and get the fight on videotapes for evidence? And wouldn't that, by definition, be putting him in harm's way?
When this pit bull attacked, not only was Goldie forced to react to defend herself, but Mr. Elvick reacted quickly and told his son to videotape what was happening, not because he wanted to encourage his son to engage in unlawful behavior or place him in danger of imminent harm. He only did this because the neighbor's pit bull was attacking his dog. And he knew that he needed video proof. That is why he asked Mikey to film what was happening. And because of that, the state has failed to meet any element of the charge of endangering the welfare of a minor.
But counsel, if in fact he conceded, I take it, that he asked his son to record it, and if the purpose was for the very reason that he posted on the internet, which is to hunt a pit bull, wouldn't that in fact be an illegal act?
If that were the reason that he had asked Mikey to film it, then that would be an unlawful act. However, he did not do this to encourage his son to engage in unlawful behavior. He only did this because he did not know that this pit bull would attack, and when it did, he knew he needed video proof of the attack.
Wasn't he anticipating something like this by leaving the notes?
There is no evidence to suggest that from leaving this note, he anticipated that this dog was going to attack. He did put a note on Miss Pawson's door because he was worried about having a fighting dog next door that is noticeably covered in battle scars and had been trained to fight other dogs. But being worried and leaving a note on a neighbor's door does not say that he intended to hunt this animal, let alone have his dog Goldie fight this animal.
How do we know that that dog was not a bait dog versus a trained dog to fight? Pit.
There is no evidence as to what this dog was used to do at the fight house. We only know that this dog was at a fight house and is covered in battle scars and at some point was trained to fight other dogs.
I don't recall that evidence. Can you refresh my memory about where we know that dog was trained to fight?
In a fight house, it's typical that all the dogs are trained to fight other dogs, even if they are bait dogs.
But we don't have evidence of that in this case.
There is no direct testimony of anyone from this house that would come and testify that this dog was a bait dog or a fight dog. We only know this dog was saved from a fight house.
Thank you.
The state has also charged Mr. Elvick with engaging in animal fighting. In order to find Mr. Elvick guilty, the state had to prove that Mr. Elvick performed any service in the furtherance of an animal fight. An animal fight being defined as a public or private display of combat between two or more animals in which the fighting, killing, maiming, or injuring of animals for amusement or gain is a significant feature. Now, when this fight dog attacked, Mr. Elvick didn't perform any service in the furtherance of an animal fight.
Counselor, wouldn't you say that videotaping a dog fight would be the further? There's an argument that that could be furthering.
The taping of what was happening was not done in the furtherance of an animal fight or to keep these dogs fighting. There was nothing done to further the fight. There was only Mr. Elvick trying to gather evidence because his dog had been attacked. But
That's your argument, though, as to the purpose, that your client's intent. You do concede that your client did ask his minor son to videotape a dog fight.
Mr. Elvick asked his son to videotape his dog being attacked, not an exhibition of an animal fight. But Mr. Elvick didn't perform any service to further this fight. In fact, he did the only thing he could think of to separate these two dogs. Mr. Elvick used his...
Sorry, I'm going to interrupt you there. There's testimony that the only thing he could do, you're saying the only thing he could do to stop this fight, but there's testimony that he's pumping his fist in the air, which matches the testimony of his best friend and hunting buddy that says he does the same fist pump in the air when he gets excited seeing his dog killing another animal.
There is testimony from Mr. Elvick's son, Mikey, that he does do a fist pump in the air when this attack occurs. But Mikey had been on hunting trips with his dad before. He knows that his dad does this fist pump when he's out hunting. He knew exactly what to say to try and make his story believable and to try and make it seem like his dad did command Goldie to attack Miss Possum's pit bull, when the evidence does not support that ridiculous story.
But isn't it corroborated by his friend?
The friend had also been on hunting trips with Mr. Elvick. He did testify that when hunting, Mr. Elvick does do these fist pumps, which matches up with how Mikey knew to add this fist pump into his story when he came into court and testified against his own dad. However, Mr. Elvick did the only thing he could think of to separate these two dogs. He used the whistle he had trained Goldie with to try and separate these two dogs by giving Goldie the command for retreat, to try and escape from the fight dog that had attacked. But Goldie was forced to defend. Now, Mr. Elvick gave Goldie the command to retreat because he didn't want these dogs to fight, kill, maim, or injure each other. The last thing Mr. Elvick wanted was for any dog to get hurt, let alone his beloved dog Goldie. Because of that, the state has failed to meet any element of the charge of engaging in animal fighting.
Why did he only have Goldie retreat after Mrs. Pawson came out?
Miss Pawson came at the end of this attack on Goldie. She only saw what happened at the end. She could not possibly testify as to what happened before she came out. So Mr. Elvick testified that he gave Goldie the command to retreat from the start. There is no testimony saying that he did not try to separate these two dogs right when Goldie was attacked. Unfortunately for Mr. Elvick and Goldie, by the time he got Goldie away by giving her the call for retreat, it was too late. What started as a day of father-son bonding for Mr. Elvick ended in severe trauma for Goldie.
Counselor, are you really suggesting that after all that gone on between Mikey and his dad, that his father was trying to bond with him that day by having him videotape his golden retriever out in the backyard?
It was not Mr. Elvick's intent to... Mr. Elvick tried numerous times to bond with his son. There is testimony that Mr. Elvick tried to help his son, sent him off to boarding school when he started acting out. He tried over and over again to bond with his son the only way he knew how, through hunting. His dad had taken him out hunting, and it was a bonding experience between him and his own father.
Any evidence in the record that Mikey seemed to enjoy this? Didn't his father call him a sissy for wanting to be a nurse?
There is testimony that Mikey disliked his father. A lot.
To commit perjury, in your opinion, right?
Correct. But you heard how Mikey feels about his dad. He blames Mr. Elvick for his mom leaving. He resents his dad so much, he even plans to change his name. It was that animosity for his dad that led Mikey to come and tell this unbelievable story about his dad planning this entire dogfight.
Don't we also have a history, though, of your client failing to assume responsibility? Isn't he always blaming others? He blamed other people for leaving the police force because they made up these allegations against him. He blames his wife for having an affair, and that's why she left. He's now blaming Mikey for testifying falsely, and it's Miss Paulson's fault to have a pit bull. Shouldn't he be held accountable for this?
If Mr. Elvick had intended to engage in animal fighting, then yes, he should be held accountable. But however, this was not an animal fight. This was simply an attack by the neighbor's pit bull attacking his dog. That is all. Now, Mikey he took the stand and he told you a story about his dad planning this entire dogfight, that his dad said today they are finally going to get that pit, and that his dad used a whistle to put this entire plan into action. But there are certain things about Mikey's testimony that just don't make sense. There's nothing that makes sense about a 35-year veteran police officer throwing away his reputation and his life's work for a dogfight. There's nothing that makes sense about a veteran police officer creating a videotape of illegal activity that could so easily be used against him. And there is nothing that makes sense about a father who has tried to instill discipline in his son, conspiring with that son to engage in a dogfight. Yet, the state has charged Mr. Elvick with conspiracy to engage in animal fighting. In order to find Mr. Elvick guilty, the state had to prove that Mr. Elvick intended to commit the crime of animal fighting, and that Mr. Elvick agreed with one or more persons to commit the crime of animal fighting.
Counsel, wouldn't you agree that if we were to find Mikey Jr.'s testimony credible, that at least in the degree that his father asked him to film this, that if in fact it was an animal fight, that would be an agreement?
That would be an agreement if somehow Mr. Elvick knew that this dog was going to be outside. Mikey testified that his dad said that today they're finally going to get that pit. But if Mikey's to be believed, that means Mr. Elvick planned to sit outside all day, in the off chance that this pit bull would be left out.
Isn't that pit bull let out virtually every day? I mean, there's no, the dog, the description of the property that is in evidence shows a fence that just ends, and then there's this sort of common forest area. So in 4 months, hasn't your client seen the behavior of Ms. Pawson and this dog?
There is no evidence in the record to suggest that Ms. Pawson lets her dog out at the same time each day. There's nothing that would suggest Mr. Elvick would know that waking up before sunrise on a Saturday, he would somehow be able to catch this dog outside.
But we do know that for 4 months, there were no issues between the two dogs. They were separated by one fence.
There was a fence separating the 2 yards. However, Mr. Elvick was in the public woods.
But for 4 months, we have no evidence that these dogs went at it.
There is no evidence that these dogs had any prior fights.
And is there any evidence that in 4 months, Pitt ever acted aggressive?
There is no evidence to suggest any of that other than the note that Mr. Elvick left on Ms. Pawson's door to suggest that perhaps something may have happened in the past that would lead him to leave a note asking her to control her dog. Now, Mikey wants you to believe that his dad planned to sit outside all day in the off chance that this pit bull would be left outside, that this pit bull would leave Miss Pawson's yard, go into the woods, and approach Mr. Elvick and his family. And that then, when all the pieces had fallen into place, that Mr. Elvick would have this golden retriever attack this pit bull. This pit bull that had been trained to fight other dogs. This pit bull that was covered in battle scars. Nothing in that scenario makes the slightest bit of sense. And that's because Mr. Elvick didn't intend to engage in an animal fight. He never agreed with his son to have Mikey help film it.
How can we believe your client if we know that at least a portion of his testimony he was not truthful when confronted about posting on the Happy Hunting website?
Mr. Elvick did not know that this post would be brought before him. He was caught off guard. But afterwards, he admitted on the stand that in a moment of poor judgment, he posted a bad joke online. Joke about having a pit problem, asking if anyone ever hunted a dangerous dog. While this was an instance of poor judgment, Mr. Elvick told you it was meant as nothing but a joke. And you can even see that because he ended the post with ha ha ha. At the end of the day, we know this is simply a case about 2 dogs that got into a fight. Yet it has led to serious charges that Mr. Elvick intended to have his golden retriever attack the neighbor's pit bull. But charges this serious cannot rest on evidence this week. There is nothing that shows Mr. Elvick intended to have Goldie attack Miss Pawson's pit bull or to have his son Mikey help film it. There's only evidence that these 2 dogs got into a fight and that one of them had been trained to fight. That was Miss Pawson's pit bull. Unfortunately, it doesn't matter whether this pit bull was the way it was because of nature or nurture. It only matters that this pit bull attacked. Because of that, you must find Mr. Elvick not guilty. Thank you.